to this webinar. 15th of May is 10 days away from the GDPR-D-Day of the 25th of May, and so welcome along to this 10 days to go, 10 things to do webinar. My name's Mark Gracie, and I'll be running the webinar, but the webinar is, I'm running the webinar in association with Insightful UX, and I'm just going to give Chris Newnham from Insightful UX a few moments to do a quick introduction. Over to you, Chris.
Cool, thanks, Mark. Hope everyone's had a good afternoon, enjoying the sun. Yeah, as Mark said, we're running this this webinar in conjunction with Insightful UX. For those that don't know, we are a digital marketing and user insights consultancy. Fundamentally, we're all about providing great online experiences for our clients. And ultimately, good experience improves conversion. And it's been interesting just over the last sort of few months as the run up to the GDPR deadline looms. Just the number of, I'm sure you've all got similar emails, number of other companies updating their privacy policies, getting clients to re-opt in, trying to cleanse their data, and it's been quite interesting to see. But also, you know, when GDPR was first announced, there was a lot of I guess scaremongering, like what's it really going to mean? And I think people have gradually got their heads around it. But I think really, as a marketeer, it actually presents more of an opportunity for us to cleanse data, improve conversations that we're having with our clients, certainly for the companies and the businesses that we work with. I think the real key is just not to be fearful of GDPR and use it to your advantage. So as Mark said, we started chatting a while back about putting on something closer to the deadline, you know, and with 10 days to go, hopefully by now you've already sorted out most of the elements that you need to make sure that you're compliant with your communications. But if not, then got a lot of work to do, maybe not too much, but and then here's 10 things that you can really kind of get onto. So Mark, back to you.
Okay, thank you, Chris, for that. Yeah, so welcome everybody. My name's Mark Gracie. I run a business called Flavorify Digital and a online service called the Digital Compliance Hub, and I'll tell you a bit more about that a bit later. My background is in compliance and regulation. I became a data protection manager back in 1998, working in a business that had lots of data and needed to put in place lots of protocols for being compliant with what was then a very new act. And that led to a 15 to 16, 17 year career looking at data protection, data retention policy, and compliance and regulation, mainly in the internet and telecoms sectors. So what we're going to do is we're going to run through what I plan to do is talk for about an hour, and then what we'll cover in that hour is a very basic introduction to data protection and the GDPR changes, and then talk very briefly about some myths and do a bit of myth busting. But the main focus will be 10 key things to consider, to at least attempt to do by the 25th of May. It's not entirely clear what might happen on the 26th of May or even on the 25th of May well, the 26th is a Saturday, so maybe we'll have the weekend to mull it all over. But it's not entirely clear how enforcement might go forward straight away. But as I'll mention when I talk about one of the myths, the enforcement is very reactive. So yeah, so I suspect we will wake up on the 28th, if that's the Monday of May, and we won't necessarily hear about this massive GDPR Armageddon that has swept across the nation. But nonetheless, there's lots of things that need to be done, and it's important that if you want to run a business that's compliant, then you need to think about some of those challenges and what the GDPR means to your business. So hopefully by the end you'll have a good foundation, if you haven't already, in the basics of data protection, but also some focusing around some of the key things to consider. So it's always worth just recapping on data protection and what it means. We have had a modern data protection regime since the 1998 Act, and the Information Commissioner likes to refer to the GDPR as an evolution rather than a revolution. So if you are compliant with the Data Protection Act, whilst there are some bits that are changing, and consent is, certainly from a marketing point of view, is one of the key things. But typically speaking, if you're compliant with existing data protection rules, then there's a good chance that you will have less to do than if you're not. But it's certainly worthwhile just recapping on the basics of data protection, and then some of the key things that are changing with GDPR, and then we'll crack on with the 10 key things for you to consider, preferably over the next 10 days. Just to remind you, if you've got a question as we go along, then feel free to use the question section in your control panel, and then we can pick those up at the end. Right, so GDPR and data protection basics. So key thing, definitions. Data protection is about the processing of personal data, and personal data is defined as any data that relates to a living individual. So that is literally any data. So that isn't just consumer data, that is data of contacts within businesses. It is your employees, if you have any, anybody who can be identified from any of the data. That is covered by data protection and falls within the definition of personal data. It's also worth bearing in mind that if you can identify somebody from a set of data by using another set of data, then both sets of data are personal data, even if the other one that didn't have any sort of name and address or identifiable information in it. If there's a cross-reference and you're able to cross-reference between the two data sets, then both data sets are considered personal data. In terms of what you do with data, that's referred to as processing, and that pretty much covers everything you do. It's not just the reason why you've got the data and why you're processing it for the reason why you collected it in the first place, but it's how you store it, how you edit it, delete it, manipulate it, share it, use it for statistical analysis, and so on. So you must be mindful that the definition of processing is very wide and covers pretty much everything that you might be doing with that data. And then there's three key actors when it comes to data protection. You have the subject, the controller, and the processor. The data subject is the individual whose data it is. The data controller is the organization who is collecting the data from the subject and determining how it's going to be processed. And then you may have a data processor, which would be an organization who processes the data on behalf of the controller. If you are the controller, in the sense you're collecting the data, but you're doing all of the processing and you're not using a third party to do the processing for you or an element of the processing for you, then you are just the controller. So don't think about yourself as a controller and a processor. Processors are only essentially third parties who are processing data as required and on the instructions of the controller. So in a marketing scenario, so we'll take a typical email marketing example. If you collect email addresses from data subjects, obviously the email addresses belong to the data subjects. You've collected them and you're going to determine what to do with them. So that makes you the data controller. But if you then pass those email addresses to a third-party marketing company to do your email marketing for you, they become your data processor. It's still your data, so you're still the controller, but they are processing it, and therefore they are the data processor. So those are 5 key definitions that the GDPR's got, I think, over 40 of them. So it's worth just bearing in mind that there is more to it than just those 5. But certainly when we talk about data protection, it's key to understand those terms, and because I'll make use of those as we go through. Now, in terms of the rules, these are referred to as principles, and the Data Protection Act had 8, which are the blue and orange ones on the screen, and the GDPR has reference to 7, which are the blue ones and the big green one. It still has the 2 orange ones. They just decided not to call them principles anymore, so they're equally as important. But they basically set the conditions by which you can process data. So all processing has to be lawful, fair, and transparent. So you have to have a lawful reason for processing, and I'll talk about that in a second. But also it must be lawful for you to process data. So if the law says you can't process data in this way, then it would be unlawful, and therefore you'd fail this first principle. It must also be fair and transparent. which I think is pretty obvious what that means. You have to be open and clear about what it is that you're going to be doing with the data and why you want it and why you're going to be processing it. You must only process it for a specific purpose. So when you collect data, you're collecting it for that specific purpose, and that's the only reason you can process it, unless there's another lawful reason for you to be able to process it. The data you collect and you're going to be processing has to be relevant. So if you don't need specific pieces of data, you just ask because, or just because it might be helpful in the future, then actually you can't do that. You have to only collect and process the data that is relevant for the purpose for which you've collected it in the first place. You have a duty to keep it up to date and accurate. So if somebody tells you that their data has changed, you must make sure you change your records. And if you shared it with a third party, then you must tell them to update their records as well. You must only keep it for as long as it's lawful for you to do so. That's the retention principle. So if you don't need the data anymore and there's no other lawful reason why you would be processing it or retaining it, then you must delete it or destroy it. And all processing must be done securely. And of course, lots of people think about security as being one of the key aspects of GDPR, and it is pretty key, but as you can see, it's only one of a number of data protection principles. But everything you do with data, remembering that wider definition of processing, has to be done securely. Now, individuals' rights, these are the rights of the data subjects. So all data subjects have various rights that they can expect to execute at any particular time. And when we talk about GDPR, I'll just talk about a couple of new ones and well, a few new ones and a change to an existing one. But these are the rights that the data subjects have, and it's important that you understand what those rights actually mean to you. They cover very obvious things like the right to object to processing, the right to have data deleted, the right to be informed, and so on. And then international transfer. This is quite important, and you might be thinking, well, I'm a UK business operating in the UK, so why do I need to worry about international transfer? Well, when you think about the wider definition of processing and where you may be processing data and the connotations for that I'll come to in a bit, it's important to understand what the law says about international transfer. Essentially, it says you must only process data outside of the EU if it's done so in a country that has adequate data protection, and by adequate it needs to meet the standards of European data protection law. So it needs to be the equivalent of what will now be the GDPR. That means that you either have to only process data in a country that has similar data protection, of which there is a small list, although it's not clear whether that list is being updated by the EU to reflect whether they're GDPR equivalents or not, but certainly under the old data protection directive, which is where our act is based on, there is a small, probably about 8 countries who have similar data protection regimes, and therefore if you process data in those countries, you're okay. Otherwise, you've got to look to see whether there's some kind of agreement in place. So the US, for example, has an agreement with the EU called the Privacy Shield, and signatories to the Privacy Shield are basically certifying that they adhere to European standards of data protection. Otherwise, it's going down the contractual route. So that's looking at how do you enforce what's called model contract clauses, which again, the EU provide that you have to put in place to enforce contractually on the third party that's going to be processing the data, that they have to adhere to European standards of data protection. I won't labour it too much, but as I said, it's important that you are mindful that this is one element and one of the set of rules around data protection that could be quite important depending on where your data is being processed. And then finally, I'll talk about this in a moment. When we talk about GDPR, there's a new accountability principle, which basically says it's up to you to be able to demonstrate that you're compliant, but I'll talk a bit more about that in a moment. Now, in terms of when it's lawful for you to process data from a data protection point of view, then we have these lawful bases for processing, of which there are 6. The obvious one that everybody knows about and is thinking about, and for all the reasons that Chris mentioned about all these consent messages and all that kind of thing, is consent. So if a data subject tells you or gives you permission, tells you that they're happy for you to process their data, then they're consenting to the processing of their data in that particular way. But just because everybody's heard about it, because it's the one that's changing, because it's at the top of that list, doesn't necessarily mean that it's the most appropriate one to be using, and in some circumstances there's a good chance that you probably don't need to rely on consent when you think you do anyway. Probably the best way of thinking about consent is it's an option. If you're asking for consent, then somebody's got the option to say either yes or no. So if you are intending on doing something with the data and you ask for consent, if they say no, then you can't do with the data that you intended. So if you needed to process the data, say for credit check purposes, and you're saying, can you consent to us sharing your data with a credit check agency, but you're going to do the credit check regardless, then you've set a misleading intention to the data when in fact they don't. So it's important that don't always think that consent is the lawful basis for processing. And I'll talk a bit more about that when we talk about some of the myths. If you're collecting data for the purposes of performing a contract or providing a service, then that is your lawful basis for processing. So assuming you're asking, I need this data because I need it to be able to process the service for billing you or for dispatching a product or whatever, that is your lawful basis for processing. You don't have to ask a consent for a postal address to be able to dispatch a product to somebody. You need to collect that data, and it would be obvious that you're collecting that data so that you can sell them the product or the service. So very often the data you're using in what you do for a business is likely to be your lawful basis for processing because it falls under this contract term, or it's for performance of a contract or delivery of a service. You may also be bound by legal obligations or regulatory controls that tell you must retain data for a set period of time. And the obvious example is the tax man. If he wants to come and inspect you for your tax returns, then you need to be able to retain data for 7 years. In fact, the tax laws tell you to keep the 6 years plus the current year. So that would be a legal obligation for you to retain data perhaps longer than you need it. And that would be your lawful basis for processing. In some instances, typically where there's a life and death scenario relating to the data subject, if there's if it's in the vital interest for the processing of the data of the data subject, then it is lawful for you to process that. So as I said, that's more in a life and death scenario. So a doctor, for example, it would be lawful for them to share medical information and the data subject's details to a medical professional that if something he needed to refer them purely for the data subject's interest. Likewise, I guess there is an element that if an employee collapsed at work, it would be lawful for you to disclose their name and details so that to a medical professional so that they could take care of them, and that you would say is in the vital interest of the data subject. The green bar there in the public interest only applies to public bodies, and this is allowing public bodies to process data when it's in the public interest or the national interest. So kind of scenario there is a government can process data for the purposes of addressing terrorism, for example. They clearly wouldn't go and ask somebody, can I process your data, and can you give me consent to process your data in case you're a terrorist, because nobody would ever consent to that. So if you're a public body, you might be able to rely on in the public interest as a lawful basis for processing. And then finally, a bit of a difficult one to use, but it exists nonetheless. And whilst it sounds very easy and is sort of a get out for having to worry about any of this, if you can claim you have a legitimate reason for processing the data and you have a legitimate interest, as the lawful basis is referred to, then it may be lawful for you to process data under those conditions. Now, the thing is, there's essentially 3 checks you have to do. So the obvious one is that the processing you're going to do is legitimate. So if there's a piece of legislation that tells you must process data in a particular way, you can't bypass that by claiming you've got a legitimate interest to process it differently. Equally, it needs to be apparent that legitimate interest is the most appropriate reason for you to be processing the data. So how you interpret that is up to you, but that could indicate that if you could have got consent, then that should be the reason for you to go and get consent. The second check is that it's absolutely necessary, and you can demonstrate that it's necessary that you process that data. If you didn't really need to process the data, but it would be quite interesting if you did, then that probably doesn't cut the requirement, and therefore you wouldn't be able to rely on legitimate interest. And then finally, you've also got to be sure that you can demonstrate that the rights and freedoms of the data subjects aren't impacted by the processing you want to do. So essentially, is it lawful for you to process this data in this way? Can you demonstrate that you absolutely need to do it? And does it not, just make sure it doesn't harm the rights and freedoms of the data subjects? And then you may be able to consider legitimate interests. I would say if you're interested in possibly pursuing where legitimate interest fits into everyday processing within businesses, it's worth having a look at the Information Commissioner's website. That's ico.org.uk. Go to the GDPR section, look at legitimate interests, and they've got a link to some pretty comprehensive guide, which also includes a legitimate interest assessment, which you can use to do this 3-point check to see whether it's lawful for you to be using that as your lawful basis for processing. And just a very quick note on legitimate interest and where that fits into marketing. Don't think that because the GDPR says in one of its recitals it could be considered a legitimate interest for the purposes of direct marketing, and because you believe that you have a legitimate interest to grow your business, that legitimate interest is the lawful basis for processing. To start off with, for example, the privacy regulations, and we'll talk about this in a bit later on, make reference to requiring consent in certain conditions. So if you are required by law, as I said before, to carry out a particular action like asking for consent, then you can't bypass that by claiming you have a legitimate interest. And there's lots of stuff, as I say, on the ICO website about this as well. They've really produced quite a bit in the last few weeks to sort of clarify some of this. So that's the lawful basis for processing. In terms of what the GDPR means, well, if you've not been paying attention, the GDPR is the General Data Protection Regulation. It's a new European-wide regulation. The key letter is the R. That stands for regulation, and in European law, a European regulation applies to all member states regardless of what's implemented within that member state. So our Data Protection Act is actually based on a directive, and directives get implemented in the EU in different ways by the member states. So under existing legislation, a guy in Germany believes he has certain rights according to what data protection laws say in Germany, and they're very strict and much stricter than us. However, and that doesn't mean his data or her data will be processed with the same responsibilities if it's processed in the UK, Spain, France, or wherever in Europe. What the GDPR does is it basically sets a baseline blanket coverage of compliance across the whole of the EU. So now the German guy can understand what GDPR means for his or her data, and therefore can expect that to be the same regardless of whether that's being processed in Germany, France, Italy, Spain, England, or wherever. And also there's extraterritorial reach, which means that if you are outside the EU but you're collecting and processing data because you're targeting European citizens, then it also applies to you, which is why you may have seen reports about the state of US companies and whether they're GDPR compliant, and I've seen articles about Australia and various other non-European countries as well. So scope-wise, actually very wide, and the important thing is to be mindful that GDPR applies across the whole of Europe uniformly. Interestingly enough, this still applies to us when we Brexit, because it's coming into force in 2 weeks' time. We'll still be in Europe at that point, but we have a data protection bill that basically says GDPR will be UK law. So when that's enforced, we will, at the point of Brexit, have a UK law that is basically implementing GDPR. The accountability principle I mentioned earlier, this is a new principle that basically says it's not good enough that you are compliant, you need to be able to demonstrate you are. So that means that for certain size businesses, if you've got more than 250 employees, you actually are required by law to document your processing activities. If you fall under that 250 baseline, then in terms of number of employees, then you aren't required to document your processing activities. But if you're making decisions about your interpretation of the law and how you're going to implement it, and you are needing to potentially have to demonstrate that you've thought it through and these are the conclusions that you've met, then you're going to have to document something in some particular form. And to be honest, I'd say best practice for anybody is document as much as possible, because that could well be your defence should you need one, say with the Information Commissioner asking, well, why are you doing this with the data? And you can say, well, actually, we worked it through and we decided and we concluded that this was the right approach. You might be told that that's the wrong approach, but that doesn't necessarily mean that you'll still get a fine. So having documentation and being able to demonstrate your compliance and applying this accountability principle is a great way of defending yourself against a large fine. So it could be no fine versus a fine, or a small fine compared to a big one. Consent, that of course is a major change that is coming. Everybody's talking about it, and basically, if your lawful basis for processing is consent and you're needing to ask for consent, you now need to make sure in a GDPR compliant world that you are very clear about what you're asking consent for, that the individual gives you a very positive affirmative action to opt in, and i.e. therefore give you that consent. And because of the accountability principle, you actually do need to be able to demonstrate that consent was given. So that means that you can't have pre-tick boxes anymore. You can't use wording that says things like, we'll assume you're happy for us to continue using your data unless you tell us otherwise. You need that positive opt-in. You need to have very clear about what it is you're asking consent for, and if necessary, breaking that down into different chunks if you want to do different things. You can't lump all, well, you can lump it all in one consent, but you'll have to explain it all in one paragraph or statement, and you need to be able to demonstrate it. So going back to our email marketing example I used at the beginning when we were talking about using processors, if you were to use MailChimp, for example, you would have maybe make use of their double opt-in, because that rubber stamps your consent process, because somebody will provide their email address. They get an email saying, are you sure? They then say yes. MailChimp records that, so you've met the requirement to prove that somebody gave you consent. So you can say, well, somebody's on our list because they read this messaging and explained what it was that they were going to get by consenting to giving us the email address. The double opt-in meant that they really did actively opt into joining this list, and therefore you've met the requirements of the new consent rules. As long as you're not using pre-tick boxes and using woolly wording, then you should be fine. And I hear lots of people saying double opt-in is the law. Well, it's not the law. It just helps facilitate this consent requirement, particularly the positive opt-in. Individuals' rights or new subject rights, as I said before, everybody whose data it is has a right, as a set of rights about the way their data is being processed, and things like the right to object to processing, the right to restrict processing, and so on. Probably the most famous individual right is the subject access request. That is basically an individual can say, what data do you hold on me? How are you processing it? And provide me with a copy. And the GDPR has updated that to say that you've got to provide that information for free, and you've got only a month, where before you had 40 days. So if you deal with subject access requests, there's a good chance you're going to get some more, and you won't be able to charge the massive £10 plus VAT that you used to be able to do under Data Protection Act. And then the other thing about the individual rights is there's now 3 new ones. So there's the right to be informed, which is everybody has a right to understand why you've got their data and what you're going to be doing with it. So at the point of collection, they need to understand this. And the right to be informed, the specific article, Article 13, sets out what you need to document in your privacy policy or in any statement where you're collecting data. The right to erasure is the right to be forgotten. So basically, an individual has a right to say that they don't want you processing their data anymore, and you should delete it, or you shouldn't be processing it anyway, and therefore you should delete it. The thing to note with the right to erasure, and I meant to say under consent, the thing with consent is somebody can opt out at any time and there's nothing you can do about it. With right to erasure, it isn't an absolute right. So if there's a reason why you need to have that data, then you can say, I'm not going to delete the data because I have a lawful reason to continue processing it, and you have to set out what that is. But the data subject doesn't have an absolute right for you to delete their data. So it's not a right for somebody to say, delete my payment information so that you can't bill me. That's not what this is about. This is about data that you shouldn't be processing anyway, which given the retention principle, you shouldn't have anyway, but under some legal circumstances, you may be required to erase somebody's data, and therefore, as long as you don't need it for anything else, then you should be deleting it. And then finally, the right to portability. This is a new right that says a data subject, and when they've provided data to you and you've put it in a system, or they've put it into the system, they have a right to get a machine readable export of that data, so that they can import it into another system. The law doesn't talk about using it for the purposes of switching and empowering people to switch, but essentially that's the kind of scenario where it's quite easy to explain what this is about. So you go to your current provider, say utility provider, and say, I want to move to a different provider, give me the data that you hold on me so that I can then tell the new provider, and they can then work out what the best tariff and all that kind of thing. Switching between services, but in a reality, you're going to have to consider how that might fit into what you're doing within your own business, and how your data subjects might be using that. And it hasn't got to be so they can put it into another system. If they want to download it and process it in a Excel spreadsheet, then so be it. The controller processor relationship change. Basically, Article 28 is a very important article, because it says that if you're a controller and you're using a processor, then you must make sure that you're only using GDPR compliant processors, because by relationship, if they're not compliant with GDPR, then you're not going to be. And Article 28.3 sets out specific contractual terms that need to be in place between the controller and the processor. So you need to be mindful of this wider definition of processing, because if you're storing data in the cloud, for example, that is considered processing, and therefore the cloud provider is processing your data. They're the third-party processor, you're the controller. You would need to carry out due diligence and make sure there's some kind of data processing agreement in place with the processor for that purpose. And if you're a data processor in that relationship, then there is a new liabilities and obligations on you as a processor. So if the controller is able to demonstrate, because they've carried out proper accountability, and are able to say, well, actually, we carried out due diligence, we can demonstrate that you said you were compliant, but actually you clearly weren't, and that's what led to the breach, then the finger of blame will suddenly switch from the controller into you as a processor, and you could be facing the consequences, i.e. the fine, the investigation, and so on. So that's new as well. Data protection by design and default and data protection impact assessments. Well, this isn't a new concept, because the UK's Information Commissioner's Office have been pushing privacy by design and privacy impact assessments as best practice for quite some time. What the GDPR does is basically say the same approach. You must consider data protection as by default whenever you're deciding how to process data and what you're going to do with it, particularly if you're going to be processing it in a different way or implement a new system or do something different with the data. So you must think about it at the forefront of those discussions rather than as an afterthought. And then you can use tools like data protection impact assessments to basically carry out a risk assessment. What are the risks to the data subjects, and how do we mitigate those risks? Now, specifically, the GDPR says that you must do a data protection impact assessment whenever there is high risk to the processing of the data. So, high risk to the subjects from the processing of the data. So if you're processing large quantities of special categories of data, for example, then there's a good chance that there is a high risk to the data subjects from that processing, and therefore you must carry out a data protection impact assessment before the 25th of May, in fact. And if you choose to do something different, then you will need to carry out one post 25th of May whenever you choose to make some changes or process data in a different way. Now, the Information Commissioner has indicated that whilst the GDPR talks about these high risk scenarios, you should still be carrying out privacy impact assessments regardless. So as best practice, I would say if you're going to do something different that will involve personal data, then you must carry out an impact assessment of some kind. And that can be as much as switching from a typical standard telephone line to a VoIP one where you're recording calls and things like that, to changing your provider from being a server-side CRM to a cloud-based one, or a server-side accounting system to a third-party accounting provider, or something like that. So wherever something's going to change with regards to what you're doing with the data, you need to carry out an impact assessment. and data protection officers, DPOs, mandated for certain types of business, and they're basically the GDPR says if you are mandated to have a data protection officer, then it sets out the rules that that person or that that group of individuals should be carrying out in their role. It's primarily there to dictate to a business to allow them to get the DPO to get on with their job rather than tell them to go and sit quietly in a corner and stop going on about data protection. It is about empowering that data protection officer to actually do their job. Now, the thing is, certain organizations will have to have a data protection officer. If you are a public body, you have to have a data protection officer. If you process large quantities of special categories of data, then you have to have a data protection officer. And I just realized I never talked about what special categories are. Special categories of data is data like health records, trade union membership, sexual orientation, biometric data used for identification purposes, and so on. If you do any of that processing on a large scale, then you would need a data protection officer. For everybody else, if your core activity is the regular and systematic monitoring of data subjects on a large scale, then you will need to have a data protection officer. And what that typically means is if your business is, if it's pivotal for your business to process data that is monitoring or tracking the behavior of data subjects and then determining an outcome, and you're doing that on a large scale, where large may be defined by the number of data records you're processing or the demographic or the location of the people that you're processing the data of, your market share, that kind of thing, then you will also need a data protection officer. And then finally on that slide, the other key change is a requirement to report breaches. So if there's harm to a data subject from a breach, then you must report it to the Information Commissioner. If there is high risk to the data subjects because of the breach, you've got to tell the data subjects as well. You've got 72 hours from becoming aware of the breach to consider whether it's reportable. You must record any breaches, regardless of whether you report them or not. And you must be mindful that breaches is more than just the typical spotty teenager hacking your customer database. It is unlawful access to data, the accidental or intentional deletion or changing of data as well. So there's quite a range of potential scenarios where a breach may occur that you will have to consider once you become aware of it, that a breach has occurred. If you're a processor and you are have something to do with the breach, then you have a duty to, without undue delay, i.e. as soon as possible, tell the controller that their data has been breached so that they can make the decision about whether it's reportable or not. But essentially, if a breach occurs and you're the data controller, you're going to have to tell the regulator that there's been something bad that's happened to the data, and that might inspire them to want to ask more questions. And then you've also got to tell your customers, which will possibly inspire them not to want to be a customer any longer if they don't feel they can trust you with their data. So yeah, quite a significant stick to beat you with in terms of compliance. Now, one of the things that everybody's talking about, I don't see it quite so much now, but Chris alluded to scaremongering in the past, is fines. Well, I haven't put fines on there because actually I'm going to touch on it as we go through the next few slides, but the key thing with the fines, of course, that's changing is that they're going from what is $500,000 under Data Protection Act up to 4% of global turnover or 20 million euros, whichever is the largest under GDPR. But the reason why I've not put it on there, and as I say, I'll talk about some of the things to consider going forward, and particularly on the myths, is the fact that just because that's the highest level of fine doesn't mean that that's what we're going to see. So those are the key GDPR changes. What about some of the myths? So there's a lot of common things and misunderstandings. The Information Commissioner even felt compelled to publish a series of blogs about some of the myths because they were hearing all kinds of stories about GDPR and what that actually means in terms of implementation and compliance. So I just wanted to touch on 4 key ones here. So the first one, remember what I said about the definition of personal data? The first one I hear a lot of, I don't need to worry about this because I'm only processing only processing business data. Well, if you can identify a business person from that data, even if they are an employee of a massive corporate, that is still personal data because you're identifying them in their role as an employee of that business. Therefore, data protection applies. So don't think data protection doesn't apply when it comes because you don't process consumer data. So even if you're in a B2B organization, you will be processing data of some kind unless you are unable to identify individuals within the businesses, your customers, your suppliers, or whatever. There is likely to be personal data, and therefore data protection applies. It's not just about consumer or individual data. Now, from a risk point of view, you might argue, well, business to business contacts are unlikely to cause us as much grief as consumers, and therefore you take a slightly different risk approach to it. Perhaps, I don't know, but certainly if you're dealing with consumers and individuals, then yes, there is probably a lot more for you to worry about, but nonetheless the law does apply across the piece if you can identify the individual. Second one, I need consent to continue to process data. So there's a lot of people out there thinking that they need to communicate to their customers saying, I've got your data to carry on providing the service. Can you consent for me to having it for that purpose? You'll remember when I said about the different lawful for basis for processing, if you've got data and you're processing it for the purposes of delivering on a service or entering into a contract, that is your lawful basis for processing. You don't need consent to do that. And sticking with consent, the next one, I need to re-seek consent for marketing permissions. That isn't going to necessarily be true. And I mean, one of the 10 things to do before the 25th of May, I'll talk about marketing permissions because there is, well, we're all suffering from overload or fatigue, perhaps, of all these organisations asking for consent. And I know from some of the ones I've seen that people are asking for consent in circumstances that they probably shouldn't be. So even under marketing, you may not need consent. It will depend on the circumstances, and I'll talk a bit more about that in a moment. And then the bit that I was just saying on actually on the previous slide, the worry that you're going to get fined £17 million because that's the upper limit under GDPR. So the key thing here is that the Information Commissioner has made it clear that you know, this isn't all about finding people large quantities of money. They don't have any financial benefit from finding large amounts because the money goes to the government. But they will be proportionate. They will need to align their approach across the whole of Europe because all the European regulators will need to have similar kind of approaches to enforcement. But everything's taken on a case-by-case basis. And in fact, at a data protection conference a couple of weeks ago, the Information Commissioner herself said, just because the fines are a certain number of multiples more now than under GDPR than they were under Data Protection Act, doesn't mean the fine will change. So a 20,000 fine under Data Protection Act could easily be a 20,000 fine under GDPR. So don't get too hooked up on large fines. Yes, you will get fined if you get caught doing something you shouldn't be doing, and you will be investigated and possibly written to. And if you've done something that's obviously blatantly in breach of the law, then you may just get a fine. And the first thing you hear about it is confirmation that you've been fined. But you will be asked questions, and you will, if you meet all those accountability requirements I was talking about in terms of demonstrating that you're compliant, then there's a good chance that you'll either not get such a large fine or you'll not get a fine at all. So let's move on to the 10 things to do now. Yeah, arguably, some of these you can possibly think about doing after the 25th of May. 25th of May is clearly a challenge. Yes, it's 10 days away, but we've got a weekend in between. So strictly speaking, probably only 8. But there are some key things that you really ought to consider. So I just wanted to sort of touch on those. So the first one, understand your data. If you don't have a clear picture in your organization about what data you have, how you're processing it, and what systems you're using, then you're going to be in a difficult position to be able to demonstrate that you're data protection compliant, because how can you be sure you're compliant if you don't know what data you have and how you're processing it? So you need to basically carry out some kind of audit, build a data register, a data processing register to highlight what data you have, under what circumstances, what do you do with it. And that will also help you move on to the next step, which is carrying out an action plan. You need to understand whether you've got the right lawful basis for processing. There's a possibility that what you were processing as a lawful basis before has changed, potentially, probably unlikely, but nonetheless, you need to understand what your lawful basis for processing is, and you would need to be able to demonstrate if legitimate interest is that lawful basis for processing, why you believe legitimate interest is the right one to be using. So think about how you're processing your data, and also think about where or who are processing your data in terms of those third parties that you might be using, and remembering that wider definition of processing. We'll talk a bit more about that in one of the other steps. Number 2, put a plan of action in place. So as I said, once you've understood, if you don't already, what data you have and how you're processing it, you need to decide what you're going to do next. Can you continue to process the data in the way that you have been doing it? It's particularly relevant to marketing data if consent is required and you've got the wrong kind of consent. There's one of the 10 is about marketing permissions. Do you need a data protection officer? Do you meet the criteria as defined? Would it be useful for you to have somebody within the business who is maybe a single point of contact? They might not be mandated to be your data protection officer, but having somebody who operates as the central point of focus for data protection compliance in the organization could be very helpful in terms of determining how you approach data protection compliance across your organization, particularly your employees understanding who they can go and ask if they've got a question. And you also need to think about the security of your processing. Are you processing all the data you have as securely as you possibly can? So Article 32 of the GDPR talks about the security of processing, and it says that you have to be able to demonstrate, so this is the accountability principle again, that you have put in place appropriate organizational and/or technical measures to demonstrate that you have processed data securely. So yes, it does list things like encryption and anonymizing data, but that doesn't necessarily mean that you would need to do encryption, but you would need to be able to demonstrate why you haven't chosen encryption to encrypt your data. So for example, if you've got a computer with some data on it and you lock it in a filing cabinet in an office which is locked, in a building which is alarmed when there's nobody there, so overnight, that's probably be seen as adequate protection of that laptop and the data therefore on it. You wouldn't need to apply, hire a security guard to stand outside overnight just in case you got burgled. But if that computer was stolen and got access to, how easy would it be to get access to the data on it? If the hard disk was pulled out, would somebody be able to read that hard disk and view the data? If they could, then you've got some issues and maybe you should have been encrypting the hard drive. If all the data's in the cloud and that computer is completely locked down and you can't get access to the cloud data without a series of different passwords, two-factor authentication and other bits of security, then that may be adequate. So again, when the data's in the cloud, you probably don't need to worry about encrypting it. So hopefully that's a few examples of where you need to sort of think this through. And obviously if you can document that thought process around the security, then that will go some way of demonstrating that you believed you were doing the right thing from a security point of view. And then the question that lots of people ask me about is, does this mean I can't retain data any longer? Well, actually, the principle of data retention and not keeping data any longer than you need to is a data protection principle for the last 20 years, and therefore you should never have been keeping data any longer. But with increasing capacity of computers and in some instances storage rooms and people filing stuff in storage lockers, we seem to be keeping data, or businesses seem to be keeping data much longer than they have a reason to do so. So it's important that you understand a retention policy and an approach to that retention policy within your organization so that you can make sure that you are only retaining data that you have a lawful reason to retain, and you've destroyed securely any other data that you may have that there's no lawful reason for you to keep. If you get that plan of action in place and address and think about those things, then that's clearly going to put you on the right path to understanding what you need to do and delivering on that. Now, one of the things that is best practice for any business is have a set of documented policies. You might not need the full list here. You might just need a basic data protection policy because that may be more appropriate to your business. And obviously, if you're a one-man band, having a data protection policy, enforcing that upon yourself is perhaps a bit silly. But having a documented approach to your compliance as well, as I've already mentioned, is helpful. But if you have a suite of policies, that will enable your employees to understand what they can and can't do with data. So consider a data protection policy. Consider how you set out what is acceptable from a data protection point of view with regards to IT security, bearing in mind what we were just saying. Maybe consider, if you've got a marketing team or do a lot of marketing, having a marketing policy, marketing compliance policy, particularly around under what circumstances you need consent. Have a policy on how you deal with breaches, have a policy on how you deal with subject access, and you might even want to have, maybe outside your main data protection policy, some information about, or policies around, how you deal with the right to erasure and the right to portability, for example, particularly if you need to do those manually. But it's important to have these policies in place because they will give you the detailed instructions that you might need to rely on at some point. So the subject access policy is a good example of that. You may only get one subject access request once every few years. So how do you make sure you follow the rules? And you know, there's a set number of things you'll need to do. You need to verify the subject is who they say they are before you give them the data. Do you understand the time limits and the fact you can't charge them, and so on? So get a set of policies in place, and that bottom line again, document, be it in meeting minutes where you've had the discussion or having formalized documented processes, the better placed you will be to demonstrate that you've paid attention to GDPR and what it means within your organization. Now, this is a key one. If there's one thing you do before the 25th of May, is get your privacy policy either updated or in place, because to be informed is a very important right. It's a new right in GDPR, and it gives the right to all data subjects to set out how the data is being processed. Now, that doesn't mean you need a privacy policy at every data capture point. You need to signpost your privacy policy at every data capture point, but you need to have a statement that somebody can easily find, and so typically that's a link at the bottom of your web page that sets out it under all circumstances where you may be processing data, what you're going to do with it, how long you're going to keep it, what the individuals have in terms of rights, how they can complain to you, how they can complain to the regulator, and so on. And Article 13 lists what you need to put in there, amongst other things as well. So the key thing to bear in mind is the breadth of what that policy needs to look like from a privacy policy point of view, because it is needing to address all the circumstances and scenarios where you are collecting data. So it isn't just a privacy policy that most people have on their website that says, when you visit our website, we use cookies and this is what happened with the data. It will say, when you fill out our contact form, this is what will happen with the data. We'll add it to our CRM. We will delete it if you tell us you don't want it anymore, and so on. When you become an employee, this is what happens with the employment data. When you apply for a job, this is what happens with the recruitment data, and so on. So if you want to understand the pure breadth of what you need to cover, I would have a look at the Information Commissioner Office's privacy policy, because then you'll just see exactly how wide that privacy policy needs to be. And the other key thing is it needs to be accessible. So A, it needs to be understandable, and B, somebody needs to be able to go to it and easily find the bit that refers to them, so they can go, oh, I've just filled out a contact form, but I want to know what's happened to my data. So I click on the link that takes me to the what happens with your data when you fill out a contact form on a website section. You might want to, depending on the kind of relationship you have with your customers or even your employees, have separate privacy promises or privacy statements that apply in that particular scenario. So a typical one is actually with employees. So you know, at the same time you provide a staff handbook or the employment contract, you say, here's a policy that sets out what we do with your data whilst you're an employee. And the last two bullets on there are add it to your website, because that's the key place most people are going to look for it. But nonetheless, as the last one says, signpost it whenever you collect the data. So, you know, that can be if you've got an online channel that you sell through, you obviously got that tick box to say you've read the terms and conditions. You don't have to have a tick box to say you've read the privacy policy, but you do need to make reference to the privacy policy at those similar kind of points as well. So definitely sort out your privacy policy. You also need to look at, and this is the fifth thing to consider, you need to look at how you deal with third-party processors. So remember, if you're collecting the data and determining how it's being used, you're the controller. But if you're asking a third party to process it in any particular way, then they will be a third-party processor. And that does mean being mindful of that wider definition of processing. So if you're using a CRM that's cloud-based, if you're using HubSpot, or you're using Salesforce, or Zoho CRM, or if you're using MailChimp for your email marketing or other email programs, then they are all going to be processors, and they will therefore need, you'll need to carry out some due diligence on them to understand how they are GDPR compliant, and you'll need to make sure that you've got a good understanding that they are compliant. If they say, no, I don't care about all this, then that may be something you'll need to consider as to not use them anymore. Obviously, the big known names, the Microsofts, the Googles, the Dropboxes, the MailChimps, etc., are all doing lots around this, so there shouldn't be too difficult for you to do a quick Google and find their position on GDPR compliance. But this also applies to real people. So if you outsource your payroll to a third-party payroll provider, or you have an accountant around the corner who does your accounts, if they're processing your personal data, they are a third-party processor, and you will need to carry out due diligence on them. And also, because of these contractual obligations, to consider how do you put those in place. You know, is there a data processing agreement between you and them, or the other way around? So, for example, the Article 28.3 stuff covers very obvious things, like you will only process the data in the way that I've told you to. You will return the data once you've finished with it. And so on, and then very onerous things which give the controller the right to say audit the processor. So if there is some doubts about the processor's GDPR compliance, then you need to have the ability to basically question them or audit them about that processing. Now, these terms are either going to be enforced by the processor or by you as the controller. The obligation is on you as the controller, but obviously if you're a MailChimp user, you're not going to be able to go to MailChimp with a legal document saying, I'm not going to use MailChimp anymore unless you sign my data processing agreement, because they're just going to laugh at you and say, well, no, you need to sign ours. So organizations, particularly the well-known third-party processors, are likely to have their own data processing agreements that you've got to sign up to as a controller. But if you have contractual obligations and legal contracts in place between you and a third party, then that's the point at which you may be needing to issue an addendum or an updated data processing agreement. Now, if you're the third party processor, that does mean your clients are likely to want to know what you're doing about GDPR compliance, so you might want to think about having a GDPR statement. They may also trying to enforce some onerous terms on you, but there's the data processing agreements which is talking about, or you need to look at how you put those in place with your customers and your clients and users to enforce those yourself. So make sure you deal with your third-party processors, and don't forget that may be online processors as well as people in the real world. The sixth thing to consider: what are you doing about electronic marketing? Lots of people are doing lots about it, and we're being inundated by I need to re-seek your consent for the purposes of marketing. What I would say is, have a look at the Information Commissioner's website section about the privacy regulations. So we have in the UK the Privacy and Electronic Communication Regulations of 2003 that set out what you can do with electronic marketing. So if you're doing email marketing, there may be a condition by which you need consent. So for example, if you're dealing with private individuals, you will need consent for marketing. So therefore, you will need to consider, do you have that consent, and is it now GDPR compliant? And if it isn't, you will need to work out how you're going to re-seek consent. And that's why, in most of the cases, why we're seeing so many can you consent to continue getting our marketing messages, emails being sent to us. However, the privacy regulations say if you've entered into a business relationship with them, so you've got a business relationship with the individual, even though they're a consumer, you don't need consent. You can rely on what's called soft opt-in, which is as long as they've had the opportunity to say they don't want your marketing at the point that they became a customer, then you can continue to market to them about your similar products. And in fact, this soft opt-in is even referenced in the Information Commissioner's legitimate interest thing, saying you have a legitimate interest to market your own products to your own customers. Therefore, if your email list is purely your customers, you don't need to send a receipt consent email. If you're dealing with business to business communications, provided those businesses aren't sole traders or unincorporated partnerships, then you don't need consent either. So you can scrape up a list of managing directors of limited companies off of Google and start marketing to them, and you wouldn't need consent. So you therefore wouldn't need to re-seek consent. Unfortunately, if you're dealing with sole traders or these unincorporated partnerships, then you will need to treat them as though they're individuals. So everything I just said before will apply. So just be mindful that you may not need to be re-seeking consent. But if you do need consent for the purposes of marketing, you need to look at whether you've got GDPR compliant consent, and if not, you're going to have to work out how do we go ahead and do that. And if you've got a load of data where you are thinking, well, I might use this now going forward, and I probably should have had consent, but I haven't, but I've not really used the data at all, then don't just send out an email, because if you're emailing people who aren't expecting to hear from you from a marketing point of view, consent or asking for consent is considered marketing. So if you don't have consent for marketing, you won't have consent to ask for consent, because consent or asking for consent is considered marketing, if that makes sense. If you're using third-party data, then you're going to have to consider how do you make sure that that third party has collected that data in a GDPR consent compliant way going forward. And you will also need to look at the points at which you collect data to see whether you need to collect for consent. And if you do, make sure those data capture points are collecting GDPR compliant consent, so you've not got pre-tick boxes and things like that. So basically, make sure you understand what marketing permissions you need. It may not be as bad as you think it is. You may not need to join this massive flurry of emails asking people to re-seek consent and panic that you're going to lose the numbers of people subscribed to your marketing list and so on. It may not be that bad, but you do need to understand what marketing permissions mean. And certainly that's something I can help you with, and I'll talk about at the very end about how that might work out for you. Now, something else that consent is relevant to, and this is, from my point of view, is something that's really come to light in the last week. The Information Commissioner has published its consent guidance at last. And this is it's been in draft since March last year, but last week they actually published their consent guidance. And the draft and their consent guidance says you will need GDPR compliant consent for the use of cookies. And they've even updated their cookie policy, their cookie guidance. So if you're using cookies on your website and you're using a cookie statement that says the usual thing that most people are using, which is we use cookies on our website, go and have a look at our privacy policy or our cookie policy to explain what that means. You can turn them off in your browser if you want, but click OK to say that you understand. All of a sudden, under GDPR, that isn't compliant because it doesn't meet the consent rules. And the consent rules for cookies are the same consent rules as data protection law, i.e. they need to meet the GDPR compliant requirements. So if you are using non-essential cookies, of which some of the non-essential cookies, the essential cookies have exemptions, if you're using non-essential cookies, you're going to have to look at ways in which you can actually seek proper opt-in consent to placing a cookie on somebody's computer. And just remember that Google Analytics uses cookies and they are non-essential cookies. So in essence, you will need to ask somebody whether it's all right to place a Google Analytics cookie so that you can track who's visiting your website. That's got some serious ramifications to website development in terms of how you go about seeking that consent. And it also has some ramifications about, well, what if everybody doesn't opt into your Google Analytics cookies? You'll never know how people are accessing your website. Now, I think they're going to see some more information about what this might mean in a practical sense. The ICO have indicated that they will clearly take precedence over people who are collecting personal information through cookies. But nonetheless, the law says you need consent for cookies, and now the law says you need GDPR compliant consent for cookies. So bit of bad news, I'm afraid, if you're assuming you didn't think the rest of it was bad news. So that's the seventh thing to do. I'm mindful of the time, so I'm just going to speed up a little bit. Make sure you can deal with your obligations. So remember what a subject access request means and what it looks like and how you can deal with it. The same with the right to erasure, the same to right to portability. And what I would say about those three key things is particularly subject access requests. You may never have had one, but now that they are free, there's a good possibility that you may get one now, not having had one before. Some research done last year said something like 75% of consumers now knowing that they don't have to be paying £10 plus VAT for a subject access request will be serving them on the 25th of May. So you may have those, but you need to have processes in place so that your staff and you understand what your responsibilities are for access right, the right to erasure, right to portability. You need to understand what you're going to do with breaches, and you need to be able to work out what your processes and procedures are for carrying out data protection impact assessments and privacy impact assessments when and if you need to carry them out. Number 9, train your staff. We talked about policies. If your staff don't understand that those policies exist or how they can reflect upon those and what it means for your team and for them and their roles and responsibilities, how can you demonstrate your company compliance? And in fact, the Information Commissioner, through some of the stuff that it says about how it will audit businesses, it will say, where's your policies, where's your training schedule? So get your policies in place, train your team to make sure that they understand how it applies to them. So they need to have a basic understanding of data protection. They need to understand that there are policies which they need to read and understand how they apply in their role. And if you want to use a stick, then you can talk about the consequences and talk about how not only can the company get fined, but if it's their fault and they have acted on their own, they could go to prison and so on. So consider how you're going to roll out training to your staff. And then finally, big message from the Information Commissioner: the 25th of May is the start of GDPR compliance. It's not the end. So don't think that you need to get this all done by the 20th. Well, you do need to get it all done by the 25th of May, but don't think that that means once you've done it, you don't need to worry about it anymore. Data protection compliance is an ongoing thing. You need to pay attention to any changes in the rules, in the regulations, any outcomes from any case law that might happen, any investigations that might happen, any changes to the guidance, and so on. There's a new Data Protection Act I mentioned coming, which is presumably going to be rolled out in the next couple of weeks. Which will be the Data Protection Act 2018, that essentially enforces GDPR into UK law. Not that they need to do that, but the third bullet there, the Brexit one, you might need to pay attention to what Brexit means, particularly if you're processing data relating to European citizens once we've Brexited, and whether we're seen to have adequate data protection. If you're worried about marketing permissions, I'm afraid it doesn't get any better, because there's new e-privacy regulations coming from Europe that could change everything I was very rapidly running through in terms of when you need consent. And there's a possibility that those privacy regulations, or the UK's implementation of them, could change the consent mechanism for the purposes of electronic marketing, or extend what is considered electronic marketing currently. And also, just finally, the GDPR doesn't talk about there being a requirement for the regulator, so our ICO in the UK, to have a registration scheme, but there is new law coming out which will basically empower everybody who processes data under most circumstances. There are some exemptions that will need to be registered, so don't think because GDPR doesn't talk about it, you don't need to worry about being registered with the ICO anymore, because actually ICO registration is quite key for them, because that's the funding model for the regulator. Just very briefly on that, the key thing to think about is if you don't register and it's found out that you should have registered, you will be automatically defaulted to the largest size registration, which is something like £2,000 or £3,000. So you might want to pay attention to what that might mean. There's some information about it on the ICO's website, but at the moment, it's a bill at the moment before Parliament has yet to be passed. So we're not quite sure what it's actually going to look like practically, whether this is something that will come in on the 25th of May and will be on renewal of your current registration and so on. So have a think about that and be mindful of that. So that was 10 things for you to think about and presumably, preferably, to try and do before the 25th of May. Now, if you've not started, that's a heck of a lot of things to achieve, and you might want to prioritize some stuff and take the position that actually you're unlikely to get on the radar of the Information Commissioner from the 25th of May, and therefore you can you can demonstrate that you're heading in the right direction even if you've not actually met compliance. But those are the key things you need to think about. But key message: don't panic. Help is available, and so a very short sales message. I've just launched through my Digital Compliance Hub a compliance pack, which you can download. It's a suite of documents. It contains a roadmap document with some checklists in it, as well as supporting documents. So if you need policies, there's some policy templates. There's a privacy policy template. There's a questionnaire to ask, the kind of things you need to ask your third-party processors. There's some basic guidance around data retention and so on. And it gives you access to the hub for a month. And for being on this webinar, or even if you're a customer of Insightful UX, if you use the code Insightful UX -25 at checkout, you'll get a 25% discount off of the price. If you're looking for other ways of supporting a self-service compliance, then I have the Digital Compliance Hub, which is an online service. It provides guidance and toolkits and information, and much wider than just GDPR. But it's primarily focused about GDPR for obvious reasons at the moment. But also it has a helpline. So if you need help, you can book a phone call or use unlimited email support to get those important questions answered when you need it. And if you need help doing any of it, then I provide various compliance consultancy services, from by the hour consultancy to audits, data protection manager. If you're looking for a data protection officer, I can help you with that as well as training and advice. So that was a overview of data protection, and more importantly, an overview of 10 of the things that you need to do by the end of next week. The 25th of May is a week on Friday. Any questions at this point? We've got about 15 minutes, so if you've got questions, then use the questions panel to ask them. I've got none coming through at the moment. If you're all itching to get away, then that's fine, and we'll end earlier. But other than that, please type away and ask your questions. So just some thank you messages coming through. You guys really not got any questions? Okay, so they're all of a sudden coming through now, right? Okay. So Lou is saying that asking about the soft option aspect, particularly around the marketing permission. So soft opt-in is basically your customers, or you being able to market to your customers because they're your customers. And the privacy regulations say, provided they were given an opportunity to say they didn't want your marketing, which is different than being asked for permission, then you can market your own products that are similar to the service that they've taken from you until they opt out. And of course, the other thing to say about marketing is everybody has an absolute right to opt out, regardless of whether you need consent or not. So I think the point I made was that there is some information in the legitimate interests section of the ICO's GDPR website that talks about that you can still use soft opt-in as a legitimate interest, i.e. you have a legitimate interest to market your own products and services to your own customers. So provided if your marketing email list is full of your customers, provided they have been given the option to opt out, and they continue to be given the option to opt out, then you can market to them. It's only going to get tricky if you need to worry about consent. So have a look at the privacy regulations. There's some information on the hub, and there's some information in the compliance pack about the privacy and the marketing permissions as well. So I hope that answers that question. Lucy, you say you have a question, but I can't see it in my list. So if you have sent it, can you send it again? Right. So Adrian's saying that he's read that the e-privacy regulations from the EU might make things easier. Is that so? Well, actually, the e-privacy regulations that are coming, and they're supposed to have come on the 25th of May of this year, so at the same time as GDPR, but that's just not happened. And there is some speculation that we might not see them until next year. What we don't know is what they might look like in terms of marketing permissions, and therefore whether you need consent. So there is a possibility that if they dictate what marketing permissions in various electronic marketing guises then they may make it harder for us to market to people, because you may need consent in all scenarios. Alternatively, and currently the draft is saying that it's up to the member states to determine the permissions for electronic marketing, in which case, well, what if the UK government changes its own implementation of the regulations post-Brexit or pre-Brexit to be more stricter in terms of consent and the requirements around marketing permission. So I wouldn't say that they're going to make it easier. They might make it easier for individuals around marketing, and they're going to make it easier probably around the controls for cookie consent. But right now, unfortunately, it's what I said before about cookie consent. The way to think about it is in Germany they have very strict rules for marketing permissions, and you need consent pretty much for everything. Well, if we go down that route, either directly because of the e-privacy regulations say so, or because the UK government implement it, then clearly everything I said before will potentially change. Okay, so Joe's asking, how does GDPR affect B2B marketing? Contacting someone in a company isn't personal information, it's company information. Right, okay, so the situation with B2B marketing, if you're dealing with sole traders, you need to think of those sole traders as individuals. So you've got to pretend that they are consumers, whether you like it or not, because the law is very clear in that area. But if you're dealing with people within a limited company, a PLC, a limited liability partnership, for example, their data is still personal data. So everything else you're doing with it, data protection applies. So they all have subject access rights. They have the right to be informed and so on. But when it comes to marketing, these privacy regulations, the Privacy Electronic Communication Regulations of 2003 say, provided they're not sole traders, you can market to them without needing consent. So if your marketing database is full of businesses, even though those are individuals, employees within that business, then you don't need consent, but everybody has a right to opt out. So that means that if you've got Fred Bloggs as the managing director of XYZ Limited in your marketing database, you didn't need consent to add him to your marketing database and market to him, but he has a right to withdraw consent and opt out, and there's nothing you can do about it. So the irony of all these businesses who are doing strictly B2B marketing and asking for consent is that they're unnecessarily asking for consent, but now it's too late because they've asked. So I hope that answers that question, Joe, about B2B marketing. Oh gosh, there's lots of questions. Hang on a sec. So Lucy's asking if she's a third-party processor, what does that look like in terms of what she needs to do? Well, if you've got terms and conditions which you enforce upon your clients, then I would say yes, definitely update those. Have a look at Article 28.3, and it tells you what the new processing terms need to be. There's also information on the Information Commissioner's website that talks about what those contractual terms might look like. And a GDPR statement is basically your way of explaining why you're GDPR compliant, that you have, if you have staff that they've been trained, that you've got internal policies, that you consider all the ramifications of security and so on. If you need some help in that area, the compliance pack has a GDPR statement draft template, as well as some of the questions you might be asked, because there is a questionnaire for third-party processors as well. Otherwise, the contractual stuff, you'll need to look at how you implement a data processing agreement, and that will really come down to how you have that in place at the moment. Jen's asking a good question. Can I recommend any software that can delete individual documents securely? Well, if you, I mean, if you delete it off of your computer, provided it isn't immediately easy for you to get access to it again, and you know, there's some questions around recovering from a backup and restoring a deleted file and how you process that, and you'll need a procedure for that. But that's probably all you need to do. If you mean, is there a program that can identify what you're using, what data you have on your system, and how old it is, and therefore you can sort of tick boxes and say delete these? I'm sure there is stuff around, but I couldn't tell you what they're called or even recommend one, I'm afraid. Right, so Kelly's asking, could I provide some more information about the presentation pack for training staff, which is part of the compliance pack I offer? Yes, I mean, very simply, it's a PowerPoint presentation with some sort of templated slides that run through the basics of data protection. It's not it's wordy in the sense that I've used words rather than pretty coloured bullets like I did with this presentation, but you can adapt that and use it as you see fit. It would obviously require you to run through it. What it is, I'm afraid, is it's not a way of getting somebody to read it through and then you know, do a question at a questionnaire at the end, or a test to confirm they've actually paid attention to what they've read. It is simply a tool for you to use if you want to deliver training to your staff. Yeah, so I hope that answers that question. Right, three more questions, or at least no, a couple of them are thank yous. Right, a couple more questions. So what are the implications for remarketing? Yeah, so another good question. It depends. So it depends on what you strictly mean by remarketing. Ultimately, it comes down to the expectations on the use of data. So if you, for example, have an email list which you then want to use in Facebook's audience profiling to target Facebook advertising to your customers, or people that look like your customers that are using Facebook, strictly speaking, you have to ask consent to use that, because if you're using that data for a reason that wasn't the original reason you've got those email addresses, i.e. join our mailing list, then you need consent to process the data in that way. And I think it would be unreasonable for most people to understand that you can do that in Facebook. Might be slightly more mindful of it now, given the recent Facebook Cambridge Analytica scandal. But it does mean that if you're using data in a completely different way than when it was originally intended when you collected it, you will probably need to look at what your other lawful basis for processing is, and that may fall down to being consent. I haven't seen anything from the Information Commissioner that might suggest that you could potentially claim it's legitimate interest, but I think you may be on sort of dodgy grounds if you're targeting advertising at very specific people because you're doing targeted advertising. I don't think that would necessarily meet the criteria of it being a sort of fair to the data subject. But yeah, ultimately, if you're using data for remarketing, you're going to need consent to use that, unless it was clear that that's why you've got the data in the first place. Lucy, right, so Lucy's just asking a follow-on question from a question about third-party processing, about whether a GDPR statement basically includes what you're going to be doing to be GDPR compliant. Yeah, I mean, that is essentially it. Actually, if you GDPR MailChimp or any organization that's processing data on behalf of people, you'll see that there's actually quite a lot of comprehensive information available about how they're processing data, and that's essentially their GDPR statement. So you might be able to use that as a basis for determining what you need to say. But yeah, it's essentially a GDPR statement is your declaration about why you are compliant with the GDPR. Okay, this is the last question. I'm mindful that we've run over by half an hour, so thank you for all the questions, and thanks for those that are still on the line, but I'll close it down in a second. So final question from Joe: if someone signs up to get a freebie which links to one list, can you then add them to their main list to send a monthly update? No, not unless you're clear that that's what they're signing up to. So you would need permissions to add them to your other list for the purposes of the monthly update. So they need to consent to that marketing. Okay. Thank you very much for joining. I hope everybody found that useful. Thanks for all the questions. I gradually managed to get through all of them, so apologies for overrunning. What I'll do is I'll close this down. A recording I'll put up on YouTube, and I'll send you a link to that, as well as a link to the slides, as well as some information about how you can get access to the pack, and a bit more from Chris about Insightful UX as well. So thank you very much. Enjoy the rest of your evening, enjoy the rest of the week, and good luck with the rest of your GDPR compliance. Thanks.
Thank you.